All right, hello everyone. Thank you for joining today. We will get started here in just a few minutes as everyone has a second to join us. Thank you for those who have joined. We're just going to give it another minute here while all attendees are making their way into the room. Okay, and we will just go ahead and get started. So good afternoon, everyone, and thank you for joining us today for our November BRI Care Consultation Learning Collaborative. Today, we are very excited to have with us Todd Bartimole and Jennifer Hunter with us from the Cleveland Elder Law to talk about care-based estate planning for families with dementia, including how professionals can help families accomplish their financial and legal priorities. A couple bit of pieces of information for housekeeping purposes before we get started. So today's webinar will be recorded, and the recording and accompanying PowerPoint slides will be made available after the presentation and can be found in the resource library on the Benjamin Rose website, which we have linked for you in the chat. Throughout the presentation, please feel free to submit your questions using the Q&A and chat features at the bottom of your screen, and we'll answer questions during the Q&A portion of today's webinar. Also, at the end of the webinar, you'll have an opportunity to complete a brief evaluation survey. So it is my pleasure to now introduce our two speakers we have today. Jennifer Hunter is a certified cognitive behavioral health therapist and a published researcher on caregiver health and well-being. She spent 18 years at the Cleveland Clinic as Director of Wellness. Jennifer has developed several evidence-based products and programs aimed at preventing caregiver burnout. With a career devoted to enhancing caregiver well-being, she's made it her mission to alleviate the strains they face. Jennifer has forged partnerships with physicians, nurses, and therapists to help family caregivers build a network of support, ensuring they receive the support they need to thrive. Welcome, Jennifer.
Thank you.
With us today also is Todd Bartimole. He is the founding partner at Cleveland Elder Law. He has practiced elder law since 1993. Before becoming an attorney, Todd worked with the Cuyahoga Long-Term Care Ombudsman Program, advocating for the rights of his aging clients and their families. Todd saw firsthand the challenges families faced in affording the care they deserved and needed. Todd's unwavering commitment to family fuels his professional drive. He endeavors to empower families to better care for one another with his team. Todd is a sought-after speaker in the community and to other lawyers and professionals in estate planning, elder law, and Medicaid eligibility. He is a board member and treasurer of his church, is married, and lives in Rocky River, Ohio, with his family and the family dog, Happy. So thank you, Jennifer and Todd, for joining us today, and I will go ahead and let you kick us off.
Okay. I have to share my screen, but I'll say that Happy is also our office. Happy is also our office greeter. She comes with us quite often to work, and our clients are very upset when she's not here. So we're going to talk today about care-based, I'm sorry, I'm having an issue with there we go. We're going to talk about care-based estate planning for families living with dementia. But before I do that, I just want to say that, being an attorney for over 30 years, I've seen a lot of people and a lot of problems. And one of the kind of currents that goes through all of this is that this is when someone has dementia or when someone has a cognitive issue, it's very stressful, not only for the person, but for the entire family. And being able to support the individual who has dementia is kind of our life's work. But we also work very closely with families because they're the ones who are able to support and care for the, our clients. And so I come to this from a position of advocacy. I want to advocate for my clients to be able to get the best care possible. And a lot of times getting the best care possible means having resources. And so we want to try to make sure that people have resources. So our agenda today is we're going to talk about estate planning essentials, both before and after a diagnosis of dementia or Alzheimer's or another problem that lands someone in long-term care. We're going to talk about gaps in estate plans, what an estate plan is, what problems we see regularly, and why it's important to see someone who understands the last part of life when you reach retirement age. We're also going to talk about preserving assets to provide high quality long-term care, make sure that there are assets available for things more than just paying for the facility. And in order to do some of that, we're going to talk about Medicaid rules and regulations that we think that every caregiver should know. So one of the issues that becomes very clear to us is that our clients that don't plan ahead, and we love clients who plan ahead, but the ones who don't often are delaying care because they think that they're going to lose their savings or going to get in other kinds of economic trouble. We know that over half of people who reach the age of 65 are going to require long-term care at some point. And so it's very important to be thinking about these issues as we reach retirement age. The other thing that people don't realize is that the average cost of long-term care is very expensive. It's, we have the U.S. Department of Health and Human Services in 22 said that it was about $122,400 a year. So it's quite expensive and can really run through, a person can really run through their savings very quickly. And only about a quarter of people say that they've actually set anything aside to pay for long-term care. So we have a really a very unprepared population who are potentially going to be running into a tsunami of problems as they age. So we have a we call what we do care-based planning, and care-based planning is differentiated from traditional estate planning in that we are focused on maintaining quality of life as people age, and we're trying to go from planning to protecting. And what do I mean by that? Traditional estate planning, if you go to a lawyer and you're 40 years old, there's a certain set of documents that they're going to give you, and we are planning for the what if. What if I pass away? What if I become disabled? And traditional estate plans focus very much on what's going to happen if you pass away. And that means, having a will that makes sure that the person that you want is appointed as an executor and the money's going where you want it to go. The other thing is that it's very focused on avoiding probate, maybe avoiding taxes, and reducing other kinds of risks like that. Revocable trusts are used all the time to avoid probate, and while it's a good goal, essentially it's got a very big blind spot. It ignores a lot of issues. So as we move into care-based planning, what we provide, we are providing plans to address people's disease progression, to make sure that they have access to the care that they need, and to use public benefits as much as possible to safeguard the assets that a client has. One of the first things I realized when I was an ombudsman was this is 30 some years ago, was that, and at that time it was $30. If you're on Medicaid, you get $30 a month. Now it's $50 in most places. But that just doesn't pay for very much. If you're a woman and you need your hair done a couple times a month, it's gone. So, so the question is, how do we preserve assets to make sure that people are basically not impoverished when they enter long-term care? We want to look at assets and how we can structure them to make sure that we can protect the ones that the family wants to protect, the home, different savings, and that sort of thing. And we hear a lot about the 5-year look back. A lot of people don't plan before the 5-year look back, and so we're going to talk a little bit about how we address those issues when we don't have the time to protect the assets. And a lot of times that is the crisis, is, someone falls, breaks a hip, all of a sudden they're in the nursing home, it wasn't expected, and oh my gosh, we're spending $120,000 a year, what do we do? So we try to address all of those things. So what's the concern with the traditional estate plan? During lifetime, there are powers of attorney that we use to allow someone else to do things for us. So a financial power of attorney, or sometimes what people call a durable power of attorney, typically addresses the things that have to be done in order to manage money. So my wife, who is Jennifer, who's here, if I am unable to manage my affairs, my power of attorney allows her to pay my bills and to get my insurance information, all those kinds of things that have to be done. And with a traditional power of attorney, they're usually not extremely broad. They say you can pay my bills, you can pay my taxes, you can hire a lawyer for me, a few things like that. And Ohio, which is the state that I'm from, it seems like about 90% of the time when people walk into our office, they walk into our office with a power of attorney form that is sanctioned by the state of Ohio. And whoever did that, well, I'm not happy about it, but in any case, they walk into our office with it, and they're really not powerful enough to do the things that we want to do if someone is trying to get on Medicaid. So for instance, and you see on the side, it calls it hot powers. Hot powers are things that have to be in the power of attorney in order for you to be able to do them. So gifting assets, creating trusts, funding that trust, doing things like that, those things have to be particularly indicated in the document, or else you can't do it. And as we'll find out, there are certain trusts that we have to have in order to qualify for Medicaid. In Ohio, our powers of attorney are very clear that we have the right to appoint a authorized representative for someone to apply for or manage a Medicaid application. And if we don't have that in the power of attorney, the county here often just kicks them out. So every state has different problems, and I don't want to be too particular to my state or my area, but those are issues that you have to look out for. And so without that type of power of attorney, a lot of times we end up with a guardianship, and the court is maybe very limiting as far as what can be done with the person's money. I know I've run into several judges that basically don't want anything done. They just want all the money spent before the person can go on Medicaid. So it's very good to have a financial power of attorney that is full and broad, and that will allow your agent to do the things that you need them to do. Every state has advanced directives. Typically those will be called a healthcare power of attorney or a healthcare proxy. And every state that I'm aware of has a living will. Those two documents are different. they do different things. And so the way that I typically approach this is that the healthcare power of attorney is an absolute necessity and the living will is optional. Why? The healthcare power of attorney is a three-person relationship. I have a healthcare power of attorney. I've appointed my wife, Jennifer, as my agent. She can make decisions for me when I'm not able to make them myself. She can make any kinds of decisions from do I get a flu shot this year all the way up to do I get my feeding tube removed because I'm in a permanent unconscious state. So she can make all of those decisions. The living will is typically a two-person relationship. In other words, it's kind of like a letter to your doctor that says, "Dear doc, if I'm in this condition, if I'm in a permanent unconscious state or a terminal condition or whatever, you can end life-sustaining treatment, you can end food and hydration." And both of these documents have their place. In Ohio, and this is something that you should know for your own state, and I can't tell you what it is off the top of my head, but Ohio I know, if there's kind of an inherent conflict in these two documents, right? Because I'm appointing my wife as my agent and I'm telling the doctor that I want him to do certain things if I enter a certain condition. And so at that point, you've got a doctor who has authority and you have an agent and a power of attorney that has authority. And so there's a conflict. Ohio resolves that conflict by saying, my wife doesn't get to make the decision, the doctor does. And so I don't like that because I want my wife making my decisions, so I don't have a living will. But it's very, I run into a lot of people and it's kind of rare that they understand the difference between those two. So it's an important distinction. And, I think the best way to, for me to talk about it is that the healthcare power of attorney is absolutely essential. The living will is somewhat optional. The other estate planning document that we run into is a will. And a will is essentially a list of instructions to probate court as to who you want to be your executor and where you want your money to go. And it is a roadmap for the probate court to handle the money that goes through your estate. When a will is really for the moment of death, and of course we are dealing here with people's life during dementia, and so a will doesn't really help very much. It may help the heirs if the will isn't needed because there's a trust or something, but it's not so, and it's not so crucial to the person who's passing away, except for the knowledge that the money's going where they want it to go, and the person who is in charge is the person they want to be in charge. So it's important to have a will. I don't mean to belittle it in that sense, but it's not so important in long-term care planning. So I'm going to move to the next slide. So funding long-term care, there are not a lot of options. Medicare is out there for post-hospitalization coverage. If you've been in in most places, or with most insurance, if you have Medicare and you go into a hospital for 3 days, you can come out and get rehabilitation care at a nursing home or a rehab hospital. But in terms of a long-term care facility, if you need skilled care on a daily basis, Medicare will pay for it. However, there are big limits on that. It'll pay for 100% for 20 days, and it'll pay for a portion with a co-payment for the next 80 days, and then after that, it won't pay anymore. You can get a new spell of illness, so a new set of 100 days comes to you after you've been free from skilled care for 60 days. Veterans benefits are available to those veterans who have served at certain times in war, and essentially if they've served in war, they can get an increased pension, which will help to pay for long-term care. There are also other veterans benefits where you can go to a veteran's home and have care paid for, in a great percentage. But typically, veterans benefits are not an all-time solution. People who have long-term care insurance, obviously, they can tap their long-term care insurance to pay. We find fewer and fewer clients are getting long-term care insurance. The long-term care insurance industry doesn't like writing long-term care insurance policies. There are a lot of hybrid life insurance policies that now pay for long-term care. So people who are planning ahead may be looking into those kinds of things, which can be very helpful in increasing options for them of where to go and how to pay. Without any of those three, you are kind of relegated to private pay, paying out of your pocket, or trying to get Medicaid to pay for long-term care. In most states, there are waiver programs. Ohio does have a waiver program that allows for in-home care called Passport. So it's like you can get nursing home care at home. In Ohio, we also have an assisted living waiver, which pays for assisted living costs, assuming that the assisted living is a Medicaid provider. Almost all nursing homes will take Medicaid. The ones that don't are usually few and far between, but nursing home care obviously can be paid for by Medicaid. So how do we get eligible? We usually think of Medicaid as a three-prong process. We need to look at each of those three prongs in order to make sure that someone is eligible. So in order to get someone eligible, we first need to look at the medical issue. Are they sick enough to require long-term care? And basically, you can be eligible medically if you need hands-on assistance with 2 activities of daily living. Hands-on assistance typically means that you can't just do it with someone sitting in the room. You have to actually need their help. Activities of daily living, I'm sure most of you know what they are, but basically bathing, dressing, feeding, transferring, toileting, those kinds of things are activities of daily living. So if you need hands-on assistance with 2 of those from a care provider, then you would be eligible for Medicaid in most states. Another way to do it is you might need no assistance with 2 ADLs, but if you have a cognitive issue that requires you to have 24-hour supervision due to danger that you might put yourself in, it could be because of a cognitive decline or an illness that requires you to have 24-hour supervision, Medicaid will also pay for that. There is an ADL that has to do with medication administration. That is usually only considered an ADL if you have something like Parkinson's, which prevents you from actually giving it to yourself. It's not something where mom forgets her medicine at 3 o'clock and needs a reminder. It's a little different. So if you meet those criteria, or someone meets those criteria, then we've met the first of the 3 prongs. The second prong is income, and in most states, are called an income cap state. An income cap state basically says if you get more than $2,901 this year, if you get more than $2,901, you are not eligible for Medicaid. Per month, yes, not per year. So for those who do get more than $2,901, they have to go through a process of what some of my friends call money laundering, which is really not what it is, but it's just kind of funny. You have to take part of the money, the part over $2,901, and put it into a trust called a qualified income trust or a Miller trust in order to qualify. Medicaid knows that money's there, so typically you have to spend it, but they choose to look the other way and say, okay, now you have less than $2,901, we're not going to count the QIT money, and so therefore you're eligible. This only has to do with the person who's applying for Medicaid. It does not have to do with the spouse. So if the spouse has $4,000 a month and the person we're trying to get eligible for Medicaid only has $2,000, there's no QIT is needed. It's only the applicant's income that we're worried about. And the spouse's income does not count towards the nursing home resident's income. So assuming we are less than 2901 or we have a QIT, the income prong is met, and then we move to assets or resources. So assets or resources are deemed countable or not countable, or countable or exempt. There are exempt assets, which we'll touch base on shortly, but essentially to qualify for Medicaid, if you're single, you can't have more than $2,000 in countable resources. If you have more than $2,000 in countable resources, then you're not eligible. Income is not the same as an asset. So if you have $2,000 in your account and you have $2,000 of income in the month that you apply, that $2,000 in income does not count towards the assets. So they're separate. If we move into the next month and that $2,000 stays in the account, now we have too many assets. So we want to be careful about that. For married couples, there's a little bit more complication. For married couples, we have to determine what's called the snapshot date. We have to determine when the first continuous period of institutionalization has occurred. And what that means is that a person's been in a hospital and or nursing home for a period of 30 days or more. Once that happens, the first date of that month that it happens in is considered the snapshot date. Why is that important? It's important because spouses are considered one economic unit, and what Medicaid does is they say, we want to know how much money you had on the snapshot date, and we're going to divide that in half in order to consider, or in order to determine how much we need to spend down or get rid of. So for instance, if a married couple comes into us and they have $200,000 in countable resources, the spouse who lives at home, the community spouse, is going to be able to keep $100,000, which is half. And the spouse in the nursing home now has to spend down their $100,000 to $2,000 before they're eligible. So the couple together would be allowed to keep $102,000, and then the spouse in the nursing home would be eligible. There is a ceiling and a floor on that. And so what I mean by that is that if we have a client who has $500,000 in countable assets, the most that the spouse in the community is going to be able to keep is $157,920,000. So we have to deal with or plan for the remaining $332,000 or whatever it is that's remaining over that $157,920. So it starts to become more unfair to the spouse in the community once you get over about $315,000. So the biggest area of confusion for our clients and for people in the general public, I think, is gifting and the 5-year look back. And so when I'm describing this to client, I don't like to call it a 5-year look back. I think it's confusing. I think basically it is a reporting period. It's a 5-year or 60-month reporting period where an applicant needs to disclose to Medicaid what gifts they have given over the past 5 years. And we have clients who get caught up in this. They've got 3 grandchildren, and within the last 3 years, they've all gone to college, and they've given them each $20,000 for college, even Steven. And then someone has a stroke and has to go to a nursing home, and so now we've got this $60,000 in what Medicaid is going to consider improper transfers over the last 5 years. So we need to deal with that. And so we're going to talk about how that works. When every state in the country has a different divisor, it's a different number. And what the federal government has said is, state, you have to decide what the average cost of a average private pay cost of a nursing home is in your state. I'll use my state as an example. It is $7,877. Where they got that number, I don't know, because it's wrong, but that's the number we have. So anytime someone has transferred money in the last 5 years, we have to divide that by the state number of 7,877. To make my math easy, I'm going to pretend that Ohio has a $10,000 average cost of a nursing home. And so if my client had transferred that $60,000 to their grandkids, they're going to say, okay, you transferred $60,000. We're going to divide that by $10,000, which is the average cost of a nursing home in Ohio. And we come up with 6 months. So 60,000 divided by 10,000 is 6. 6 is the number of months that Medicaid is going to refuse to pay. And generally they refuse to pay from the date that you are otherwise eligible. So you have to spend down to the $2,000 before that penalty period starts. Once you get past the 6 months, Medicaid will start paying as long as the person is under the $2,000 still. So it can be tricky because the way that, essentially the federal government doesn't want middle-class families giving away their money and becoming eligible for Medicaid earlier than they would otherwise. So we have to, as advocates for our clients, we have to figure out, well, how do we transfer that money or cover for that transfer without preventing the person from getting care. So often the first thing we look to is, are there any exceptions? So if the 3 children were disabled, we wouldn't have a problem because a person can transfer money or a house to a disabled child. And that is an exception to the improper transfer rules. There's also a child caretaker exemption for the house. So generally, and each state has a different way of proving this, but if a person has lived with a child has lived with their parent for the last 2 years, taking care of them, and during that last 2 years, they required a nursing home level of care, the government has basically said, we're going to allow that child to continue to live in the house and for the parent to transfer the house to that child, because essentially they've kept them out of a nursing home for 2 years. So that is one of the major exceptions. There is a trust called a sole benefit trust that is essentially an exception to the improper transfer. It says that if you put money into a trust for a person on Medicaid, or if they put it in for a spouse even, that trust has to distribute the money in an actuarially sound way. So they have to figure out exactly how much they have to distribute every year, but that can be a way of, in the right situation, can be a way of protecting money without incurring any penalty. There's no penalty for putting money into a sole benefit trust. Now, irrevocable trusts, on the other hand, are typically improper transfers. If you're moving money to an irrevocable trust, usually you're doing it in order to prevent Medicaid from being able to count those assets. So we use irrevocable trusts for this purpose all the time. We can leave our client in charge of the trust, but they usually are not a beneficiary of the trust, so they can't just take money out themselves. There are a lot of different ways that we can use irrevocable trusts to protect clients, but essentially, if a person has 5 years, they can put their house and assets into the irrevocable trust, wait the 5-year period, and at the end of that 60 months, that 5 years, Medicaid can't look at it anymore. It's done. We also use irrevocable trusts to protect money for family members if we're using another way to cover that penalty period. So if we created a 6-month penalty period, we can use other money to convert into income to pay for the facility while Medicaid has its penalty period. And the ways that many states can do that are with annuities or promissory notes or loans. And so if we had this $60,000 that was transferred to the grandkids and we have to spend down $60,000 still, we can buy an annuity for approximately $60,000 that will pay to the client or to their spouse enough money to pay for the care that Medicaid will refuse to pay for. Many states can do that with promissory notes and loans. It's not permitted in Ohio, but I do put them up there because most states can use promissory notes and loans also. So these are ways that we're able to protect money. An irrevocable trust is important also because Medicaid will try to claw back money after a client has died, and they cannot do that from an irrevocable trust. Every state is a little different. Some state recovery can only be done from probate estates. Some can be done from everything, like Ohio. Ohio is very aggressive. But the irrevocable trust is clearly not owned by, the money in the trust is clearly not owned by the Medicaid applicant, so it is not accessible in state recovery. There are a lot of different resources around. We will, because you'll have this available, you'll be able to access these resources. But the National Academy of Elder Law Attorneys is a list of, you have to be a member. If you're a member of NALA, you probably know what you're doing. There are certifications in elder law, and those people also should know what they're doing. The Life Care Planning Law Firms Association is also a good resource. They usually require that their law firms have a social worker on board in order to address other issues besides just the estate planning. The American Council on Aging has some good resources. Your state area on aging, and of course us, with that, I'm going to turn everything over to Jennifer Hunter, who, as I mentioned earlier, is not only my partner here, but is my wife, and she is going to take it from here. But thanks for listening.
Thanks, Todd. And I'm going to be brief so that we can get into Q&A. I'm sure there's lots of questions for Todd after all the information that he's covered. As Morgan said, I'm someone who's really spent my life supporting professional caregivers and, physicians and nurses, and also family caregivers. My role here at Cleveland Elder Law, we are what we consider a holistic law firm. And so I partner with our families and I connect them with the resources that they need. A lot of times folks are burying a parent, and so we're helping them with grief support. But many, many times families are coming in after having that terrible day where they received the diagnosis. and we're supporting the spouse who, is truly committed to caring for that spouse who's just received the diagnosis, or the adult children. And, just a couple of things I want to say about that. One is that caregivers feel such a deep sense of responsibility about their parents' or their spouse's finances. And there's so many myths and misinformation about Medicaid. And oftentimes people come in and they find out they've spent assets that they didn't need to spend. And so, for us, it's just, we're so grateful to Benjamin Rose for allowing us the opportunity to share this information with such a broad audience. The other thing that I always do in my role as providing the wraparound services for our clients is that I promote the BRI consultation services. In our area, that's the We Care program, because it is evidence-based. And because I am a family caregiver myself and I've experienced the benefit of that program, we make sure every family that we see knows about that program. So all of you who are community-based care consultants, I just want to say just how important the work is you do and how critical it is to the families that we serve. In my previous life, I did do a lot of research on caregiving. Just wanted to share some data that is from a robust paper that we published in the Journal of Occupational Environmental Medicine. I did this research in partnership with Johns Hopkins and Quest Diagnostic, and this was on an employed population. And so, I can see your.
Oh, I'm sorry.
That's okay. Sorry, I was distracted. This was an employed population. We surveyed 70,000 employees to look at the drivers of emotional health and well-being. One of the drivers we looked at is, do you self-identify as a family caregiver? 15% of those 70,000 employees did self-identify. And of that 15%, 7,543 identified as caring for someone with a dementia or Alzheimer's diagnosis. And one of the things that I'm really interested in always is, what are the drivers of mental and emotional health, and how is it unique to these roles that we play in our lives? And what we found is that for family caregivers, it was the highest rate of comorbid health conditions, and so that's more than one chronic condition. And so in the population, when we look at health drivers, it was higher than the general population of having at least 2 chronic conditions. The other feature that we saw is that it was the highest rate of both depression and anxiety. These were validated measures of depression and anxiety that we used, but family caregivers were more likely to have both depression, clinical depression and anxiety. And the other thing that I think is really important for all of us to think about is that when we look at what type of social support do they have, we found that it was most difficult for them to access practical support, which of course, is such a foundation of the Benjamin Rose Care consultation. And I think that when we're caring for a loved one, we think we have to do it all. And so helping families problem solve around the logistics and how do you ask for help, who can you ask for help, really is critically important when folks find themselves in the role of family caregiver. So again, Morgan, Benjamin Rose, thank you so much for the opportunity to share this information today. And Morgan, I think you're going to lead the Q&A discussion, so I'll hand that over to you.
Yes, thank you, Jennifer, and thank you, Todd. And I think if we want to, you can probably take the presentation slides down now if you want, while we move into the Q&A portion. So I know we did have one question just come in asking if you can provide a citation or a link to that study that you were mentioning. And that's also something that we're happy to send out after with a copy of the presentation slides and recording. There's been a lot of people asking for the slides because there's such great information and wanting to make sure everyone is able to digest that and reference the recording afterwards. So we definitely will have that.
Morgan, I just wanted to say that I addressed one question while Todd was asking, but I thought it was a really great question for the, one of the caregivers, Todd, said that she thinks the living will is important because it means that the family sometimes they don't want to make these really tough decisions. And I just pointed out that many people just don't understand this conflict exists, so they're not able to make an informed choice.
And that's a great point. And we use the living will when, and I didn't mean to poo-poo all over it, but we use the living will when that is the case. Sometimes people will come and say, listen, I don't think my daughter can make this decision. She can make all the other ones, and I'll say, okay, well, let's do the living will to provide that support. So it's an excellent point.
And one question I wanted to see if you could speak on a little bit. It was a question that popped up several times during actually the registration for this webinar today. We had several attendees asking about the difference and clarifying the difference between capacity versus competency, and when that determination is made. And then also kind of following up to that, if there's been documentation that has been signed pre-diagnosis, does that change any of that documentation once there has been a dementia diagnosis?
Yeah, so first of all, I acknowledge that it is a really tricky area. And we run into it constantly because people don't plan ahead. So I'm running out to ICUs and nursing homes to try to determine whether someone has capacity. So in our state, there's a test about capacity to sign a will, which also can be instructive as far as whether a person can sign a power of attorney in a lot of cases. So, I usually talk to the client. I try to get a sense of whether they're oriented, if they understand who their family is, if they understand what assets they have, and so as long as they can understand those things, typically I feel comfortable. I've had a lot of situations where a doctor has said, "Oh, this person's incompetent," and then I'll go in and I'll ask them a bunch of questions, and I find them to understand what's happening. I won't, but it can be tricky, and we have to be careful when we're doing that. There are a lot of tests that are, the Montreal test, those kinds of things that will give you an idea of whether someone has, if someone knows what's going on enough to be able to sign documents. But a lot of times with powers of attorney, I just want to make sure that they understand that they're putting their son Joe or daughter Josette or whoever it is in charge of their financial decisions. And, it's obviously a case-by-case basis. I feel like I have seen enough physicians declare people incompetent when I don't think they're incompetent. So and they're not coming at it from a legal point of view, they're coming at it from maybe a medical point of view, but only a court can declare someone incompetent. But I typically am trying to understand whether the person can form an opinion or has an opinion about who they want to get their assets, when do they want to preserve their assets for their care, those kinds of things. And if they're oriented and they understand that, then that's kind of where I decide to act from. So, it's not simple. And I've had many times where I've talked to a person, found them on the borderline, and I'll say, I'm going to come back another time and see whether they've got a better understanding. And, sometimes they do, sometimes they don't. When they do, I love it when I walk into a room and they remember who I am and say, "Oh, you're that lawyer," So I know they have some understanding of what's going on.
Thank you. Well, we have had a handful of more questions come in. So the next one, can you clarify regarding irrevocable trusts? Is it irrevocable burial account / prepaid funeral still an acceptable way to spend down funds for Medicaid eligibility?
The answer is yes. A prepaid funeral is definitely an exempt asset. It does not have a cap. So if you want to spend $45,000 on your funeral, I've never seen a case prohibiting that. I wouldn't want to do it, but but there's no specific amount. It has to be irrevocable. So if you can take the money back, it's no good. Most of the time, these are insurance policies that you're buying, so those are those are irrevocable contracts, but they're portable. You can take them to a different funeral home if you want to. I don't use the trust so much in Ohio. I think they're a valid way to do it in most states. Ohio gets persnickety about things, so I'm hesitant to do it, but it doesn't mean that it's not. I mean, if it's irrevocable and it can only be used for the funeral, and if there's extra money, it can go back to the state, then I think it's okay.
Thank you. Another question is, if paying for in-home care, paying private for in-home care, does Medicaid require a caregiver agreement to justify cost of care? In parentheses, it says not gift giving.
So if you're trying to spend down, I would recommend a caregiver agreement or a rental agreement or some kind of an agreement that puts the expenditure into an expense where someone, the idea of a gift, just to be clear, is that a person is giving money away without getting something in return, what we lawyers call consideration. So if I want to buy a candy bar, I give $1, they get the $1, I get the candy bar. That's consideration. It's something that goes both ways. So with a caregiver, you're providing care to the person, they're paying you. And that is totally fine. That's consideration. And so, but having it in writing makes a lot more of sense. It makes a lot of sense if you're a caregiver at home and you're doing that to, I don't think it's a bad idea to get a payroll service to do that. I don't think you have to, but it is income to the caregiver. They are supposed to pay taxes on it. So if you're paying taxes on it, that's a pretty good bit of evidence that it's not a gift, it's income. So I do suggest caregiver agreements in order to pay someone, if that's the way that we're going to go.
Next question is, if a gift of an exempt asset, for example, a car, taken into account for the calculation of a penalty period?
It's such a good question. And, in some ways, I don't know. And here's the reason why. It is technically an improper gift. It used to be very clear that exempt assets could be gifted. I think there have been some cases where exempt assets are still considered an improper gift if they're transferred. My knee-jerk reaction would be that it would be considered an improper transfer. For instance, the $2,000 that someone's allowed to keep, if they give that $2,000 to someone, is that an improper transfer? I don't think it should be, but there's a potential that it could be.
Are there limitations on how money can be spent down, healthcare versus credit card debt?
So again, it goes down to consideration. So if someone is spending money down, they can spend it on healthcare costs. They can spend it on credit card debt. They could not spend it on credit card debt and then have no money to pay the debt later, and tell the credit card companies that there's no money left. But the other thing, though, is that as part of our planning, if we're trying to preserve those assets, one of the things that people can spend down on is income. And I know that sounds weird, but that's what an annuity is. So if I'm married and I have $100,000 that I have to spend down, I can literally buy an annuity and say, pay the payments to my wife. And that is, at least in my state, considered an appropriate spend down. I'm allowed to transfer assets to my wife. It's not considered an improper transfer because, like I said before, they treat us as one economic unit. So that's a way of being able to keep all the money. If there has been an improper gift, buying an annuity to create income to pay for any penalty period is one of the other things that you can spend down on.
I'm going to kind of combine two of the questions here. So one says I have a power of attorney for health. And the other question says, if you have a signed power of attorney, what do you do next? How do you get it activated and what do you do next?
So the healthcare power of attorney goes into effect when a doctor says that you can't make medical decisions for yourself. So that's how it goes into effect. Getting the I mean, we recommend that, and a lot of people are in big healthcare systems now, and so it's a lot easier than it used to be. But you know, here, if your doctor is in the Cleveland Clinic and you give them a copy of the healthcare power of attorney, they're going to put it into the system, and everyone's going to be able to access that and know what it says. So, but the best thing to do is to give it to your healthcare providers so that they know who to contact when something happens. Yeah.
Thank you. And I think we have time for one more here, asking, how do I access my wife's 401k to pay for care costs before she is declared incompetent?
So that is exactly why we need a power of attorney. The power of attorney that she signs saying, her power of attorney that says my spouse or my child can access my accounts, can access my retirement accounts, 401ks, IRAs, whatever the case may be, that they can use that money to, that they can access it and spend it on my behalf.
Okay. And I want to try, we have some more questions coming in, so I want to try and squeeze in one more here.
Okay.
And this is Ohio specific. So in the state of Ohio, if a person is the agent of a family member's financial power of attorney, can they make themselves joint on the family member's bank account? Is the first question. Then does the POA document specifically need to state that the agent can do that?
Ding, ding, ding on number 2. The power of attorney has to say that you are allowed to do that. Generally, a power of attorney is supposed to somewhat, if possible, maintain the estate plan that the person signing the power of attorney had. So in other words, a joint account can be used to avoid a will. So if my will says everything goes to my wife, but my son decides to make my accounts joint and survivor with him, he's basically rewriting my will, right? So that's a power that would be a hot power. That would be a power that you would have to have written in the document in order to make it work.
Well, thank you. We have for our audience here, we have the chat saved. So we will make sure that because we have a few questions that weren't able to be answered live, but we'll make sure our presenters get those questions and we can try and get answers to those. So I want to thank both Todd and Jennifer, your guys' time today. That was a lot of valuable information covered in a short period of time. And we have a lot of people in the chat just talking about how helpful that information was. And obviously, both of you at Cleveland Utterall are great partners with Benjamin Rose. So we're happy to use this as a time to continue that partnership.
Yeah, and thank you so much for allowing us to do this. And we're so happy that we're here.
Thank you. So if you can all take a moment in the chat, you will see just a few minutes here before you head out. We have a short evaluation survey that is linked for you in the chat. Your input helps us plan these sessions and make sure that the information that we are providing is helpful for you. So completing that information will help us there. And then while you're working on that, there are a couple of upcoming events that I just want to make you aware of. So if you're local to the Cleveland, Ohio area, Benjamin Rose will be hosting our annual in-person caregiving conference on Tuesday, December 2nd from 8:30 to 3 p.m. Eastern Time at Benjamin Rose headquarters. And this year's full-day conference will explore two central themes: the caregiver experience and the policies that can better support caregivers, such as paid family caregiver leave. And in the chat, you'll see a link to the Benjamin Rose website where you can review the full agenda, and you can also register for that in-person event.
And Morgan, Todd and I will be there, and so
Awesome.
if you're there, we'll meet you there.
Oh, that's awesome. Perfect. Thank you. And then the other event I just want to make everyone aware of is also on December 2nd. So this is the National Dementia Care Collaborative. They are hosting a virtual forum from 2 to 3:30 p.m. Eastern Time entitled The Comprehensive Dementia Care Beyond Program Launch. And during this session, experts from the Centers for Medicare and Medicaid Innovation will share what they've learned during year one in the guide model implementation program and field questions. And they'll also have participants giving insight into the lived experience and then looking at innovative approaches to dementia care models. And then finally, again, and then a link for that, a link for this webinar is also pasted in the chat. And then finally, anyone that's attending today's webinar that maybe has questions about Benjamin Rose's evidence-based program, BRI Care Consultation that Jennifer mentioned, or our guide model services through WeCare, we've included Michelle Palmer's email in the chat, and you can email Michelle with any questions that you have. You can schedule a one-on-one conversation or a demonstration of the program. We are always happy to do that. But other than that, Todd and Jennifer, thank you again for today, and thank you all for joining us, and have a great rest of your Thursday.
Thank you so much.
Thank you.
Bye.